Welcome back to the David Pakman Show. I'm Farron Cousins sitting in for David Pakman today. Um, and just keeping with what we were talking about in the first segment of the show, one more discussion about guns in the United States. And this discussion actually came from Supreme Court Justice Clarence Thomas. Clarence Thomas is typically the quiet SCOTUS judge. He's not a guy that really likes to go out there and talk a lot, either to the press or during actual hearings in front of the Supreme Court. But this week, Clarence Thomas decided to get a little bit outspoken on the issue of Second Amendment rights in the United States. And he also, by speaking out, not decided, but he showed us how little this man actually knows about what the United States Supreme Court has done on the issue of the Second Amendment. What happened was that the Ninth Circuit Court upheld a 10-day waiting period in the state of California for guns. The U.S. Supreme Court decided they were not going to take up the case, which means the Ninth Circuit's ruling stands and says, yes, California, you can have this 10-day waiting period for people seeking to buy guns. Actually makes a lot of sense, right? If anybody goes into a store and says, I need a gun right now, I can't wait, probably not the kind of person you want to sell a gun to, right? So Clarence Thomas decides, you know what, I'm speaking up. I'm speaking out. And here's what he had to say. The court would take these cases because abortion, speech, and the Fourth Amendment are three of its favored rights. The right to keep and bear arms is apparently the court's constitutional orphan. So Clarence Thomas thinks the poor little Second Amendment is just forgotten by the Supreme Court. Now, this is the same Supreme Court that back in 2008 upheld D.C. or overturned, I should say, laws banning handguns in Washington, D.C. At every possible opportunity in recent history, the United States Supreme Court has pretty much gone in favor of the Second Amendment of gun owners. And so for Clarence Thomas to come out and say that the Second Amendment is the forgotten orphan of the Constitution, you know what? I'm going to go out on a limb here and say that in reality, probably the Third Amendment is kind of the constitutional orphan. That's not one you really hear much about. And I guarantee you most Americans have no idea what the Third Amendment to the U.S. Constitution actually is. But come on, especially at this point, with everything that has happened, I mean, hell, in the last decade, with guns in the United States and the issue of gun violence and the prevalence of these weapons of war like AR-15s. Yeah, something needs to be done. And if it's a 10-day waiting period, if that's the best we can get, we have to take it, but keep fighting for more than that. And Clarence Thomas is lying through his teeth at this point. Oh, it's the forgotten orphan of the Constitution. That is such a crock. The Second Amendment is something that the Supreme Court itself has allowed to be morphed into this whole theme that Americans have the right to own whatever kind of gun they want, even if it's something that was specifically designed to kill 60 or 70 human beings every minute. The Supreme Court is right. The Supreme Court is why we're in this mess. They're the ones who did this to us. They could have many years ago said, you know what? Yeah, the Second Amendment says the right to bear arms, but that doesn't mean firearms. That just means like swords and knives, because those count as armaments. They could have ended this long before it started, but they didn't. They could have said that, no, it doesn't mean that you have the constitutional right to own a high-capacity machine gun, but they didn't. So Clarence Thomas, not only does he clearly not understand what the Supreme Court has done with the Second Amendment over the years, but I think his little recent tirade here shows that he should probably go back to just staying quiet because he has no idea what he is talking about on this issue.